As a private investigator, you will most likely at one point or another in your career have to take the stand and give sworn testimony regarding one of your investigations. And if you are not a PI, well, you may at some point in your life have to give testimony in court related to a case you may be involved in or a witness to, such as a divorce, small claims court, or even as a defendant in a legal matter. When giving testimony, when you have to take the stand, there are some things you should do as well as some things you should not do. Let me know in the comments below if you have ever had to take the stand as a PI or for any reason and how many times. And let me know what were the hardest parts for you when you had to testify in court. Now, a key thing to remember, regardless of whether it is a criminal matter, family law matter, small claims court, or whatever the case may be, you are giving sworn testimony. That means you are giving an oath saying what you are stating is the truth, the whole truth, and nothing but the truth. And that is the first rule to remember. Always give the truth no matter what, even if it makes you, your client, or anyone else look bad. If you are not truthful and that comes out in court, you can and many times will be held in contempt of court. And contempt of court is a criminal matter that is punishable with fines and even jail time. Not to mention one time, that's all it takes, one time for you to be proven a liar in court, giving bad testimony, and you may never be able to take the stand again. Your clients won't want you to take the stand for fear you will not be truthful. The court won't want you to take the stand as your professionalism is in question. And the other side, well, I can almost guarantee they will want to let you take the stand so they can tear apart your testimony, and many times they can do that simply by bringing up your past untruthful moments in court. And yes, the other side will do a complete background on you looking for those types of things to hold against you. This video is sponsored by OREP Insurance and Working PI Magazine. OREP is a leading provider of private investigator liability insurance. Visit orep.org for a quote today. But before you ever take the stand, before you ever step foot in the courtroom, I always suggest checking the courtroom out ahead of time. Yep, I do recon on the courtroom, so I know the layout of the courtroom, where the witness box is, where the defense sits, where the prosecution or plaintiff side sits, where the jury box is, and everything else. The day of court is not the day to do this either. When you show up for court, you as a witness will most likely have to sit outside the courtroom or in a separate witness room. Knowing what it looks like ahead of time allows you to look alert, knowledgeable, and professional when you walk in for the first time to give testimony. And looking professional is the next thing we need to discuss. You need to have a professional appearance as a professional investigator. I always recommend a suit and tie for the guys and a dress suit for the gals. And if you are not a PI, I still recommend looking professional. Maybe not a suit and tie, but a nice button-up shirt or a collared shirt and slacks. We have all heard the phrase, first appearances are everything, and in court, this is true even more. From the moment you walk in the door, everyone in the courtroom, judge, jury, and the attorneys are all watching you and sizing you up. If you appear professional, if your appearance makes you look credible, that goes a long way in helping them to believe what you say and trust the testimony you give. If you have a wrinkled shirt on, baggy jeans, old sneakers, messy hair, or things like that, they will stereotype you and they will give less credence to what you say. Going along with looking professional, you need to act professional too, and this starts with the moment you get on the property. You never know who is watching you from the moment you pull into the parking lot, walk up to the courthouse, and sit down outside the courtroom. I have had clients ask me to scout out the witnesses for the other side before the court starts. So I observe them when they arrive while waiting to give testimony, and I make observations of how they acted when they left after giving testimony. This information is very useful to the attorney working on your side of the case so they know how to prepare for those hostile witnesses. Here are the do's and don'ts while giving testimony when you are on the stand. First thing is to listen. I mean, listen very carefully to the questions the attorneys ask you. If you are familiar with doing interviews, you know the difference between open-ended and closed-ended questions. An open-ended question is one that elicits more than a simple answer. A closed-ended question is one that only needs a simple answer like yes or no. If the attorney asks you, did you do a scene investigation, then the answer is quite simply yes or no, nothing more. Many times the other side will ask questions like this, trying to get you to tell them all about your investigation. You do not want to answer with, "Yes, I did. I took pictures and measurements and interviewed witnesses during my scene investigation." While that may be true, it allows them to then address each of your statements in detail without ever having to reference your reports. Also, when you answer the question, always make eye contact with and address the person who asked the question. One caveat to this is if your attorney instructs you to look at the jury when answering the question. This is usually asked of more for defendants, but sometimes an attorney will want his investigator to address the jury. Kind of along the same lines, do not look at your attorney and answer the question from the other attorney. This makes it appear as if you are uncomfortable answering the question. As well, it makes it look like you are looking to them for answers or guidance. Before you answer the question, always take a moment to reflect and give it a second or two. This not only allows you to think about how to address the question, but it also gives your attorney time to object to the question should they need to do that. If you start to answer right away, then your attorney objects. Even if the judge sustains or agrees with the objection, the words are already out of your mouth. And even if the judge tells the jury to strike your remarks and not consider them, well, to be truthful, they cannot unhear what they have already heard. I know giving those pauses, even for 2 seconds, can seem like an eternity, but it really isn't, and it does give the appearance of professionalism as you are thinking about the question. One exception to the rule of not looking at your attorney when the other side asks you a question might be if you think the question needs to be objected to. But use this with caution and with advisement from the attorney ahead of time. I always tell the attorney, if I think the question is out of line, I may look over at you quickly. Some attorneys will say okay, and others will say no need to do that. And if you are doing it a lot, remember, it makes you look like you are looking to them for answers or for help. When you do answer the questions, if it does entail more than a yes or a no, always give the shortest possible answer and never offer more detail than what is asked for. If the other side asks you to tell the court what you did during your scene investigation, then an appropriate answer would be something like, "I took some photos and measurements and interviewed witnesses." You do not need to say, "I took 124 pictures of the scene." According to our standard procedures, those pictures included faraway shots, closer shots, and close-up shots of tire marks, damage to the fence, street lighting, and other important factors. The measurements were taken using a rolling measuring device like the ones the cops use, as well a 25-foot and a 100-foot Stanley tape measure. I also interviewed 20 people during my neighborhood canvass, 4 of whom were witnesses to the event, and 5 others had security cameras pointed at the scene, so I got them to send me the video they had. This is TMI, too much information to be sure. Once introduced into the court as your testimony, they can cross-examine you on all of that. You have to keep in mind, especially in regard to criminal defense cases, the defense attorney probably did not give the prosecution all of your reports. So the prosecution has limited information. In criminal matters, the prosecution has to provide everything to the defense during discovery. It is their job to prove guilt. The defense, however, must only disclose what they plan to use in court. It is not their job to prove innocence. And if you introduce new evidence through your testimony, well, that adds ammunition to their case. One of the biggest things you need to learn is to not fall for the other side's traps. They will try to use everything in your reports, your investigation, and your testimony to antagonize you and bring doubt to the jury about your abilities as an investigator. You need to be prepared for this and make sure you do not get emotional over the questioning. That is where those pauses, those moments of reflection before you answer a question come in. Give your attorney time to object should they need to, and give yourself time to get a breath of air. Consider the question and give an appropriate answer. Don't take the cross-examination personally. You have to keep this in mind. You have your job and they have their job. All they're doing is their job. If they get you to react in an inappropriate way, well, they did their job better than you did your job. And here is the biggest tip of all when giving testimony. If you make or made a mistake, just admit it. If they find a discrepancy, the best thing is to admit the mistake and move on. If you try to defend the mistake, it puts you on the defensive and it makes it look like you are trying to cover things up. Now, check this out. If you want to know more about being a professional private investigator, then check out this video.